We have with us for the final session of the day an excellent panel, and the topic is as excellent. Taking of evidence in arbitration, are there any rules of the game? Just a brief introduction of the topic. The freedom to determine the rules of procedure, including those of taking evidence in an arbitration, unfettered by the technicalities involved in court proceedings, is one of the primary concerns that arbitration has been the preferred mode of dispute resolution in recent times. However, keeping in mind the limited scope of challenging an arbitral award, the question arises as to whether such procedural freedom is truly unfettered. The session discusses that while the agreement between the parties is of paramount importance, rules of natural justice and fairness cannot be ignored. It is my absolute pleasure to welcome the panel, starting with the chair of the session, Honorable Justice Abhay Oak, Supreme Court of India Judge. Justice Oak is a sitting judge of the Supreme Court of India. He completed his BSc and LLM from the Mumbai University and enrolled as an advocate in 1983. He's practiced for 19 years before the Bombay High Court. In 2003, he was appointed as an additional judge of the Bombay High Court and in 2005, a permanent judge. He went on to be appointed as the Chief Justice of the Karnataka High Court in 2019 before being elevated as Supreme Court judge in 2021. During his tenure as a High Court judge, he passed many orders on environmental protection and for better living conditions in Bangalore and Bombay. During the COVID-19 pandemic, he passed several orders protecting the right of migrant workers and questioned the handling of the government. Justice Oak's conviction to uphold justice, social change, and preserving administrative accountability can be reflected through his judgments, like right to protest and requirements of Section 144 of the CRPC, the right to shelter, that is, upholding the state's obligation to provide shelter to the homeless under Article 21 of the Constitution, and ordering the setting up requisite night shelters for the homeless across urban states in the state. We also have Mr. Justice R.D. Dhanuka, Judge of the High Court of Bombay. Justice Dhanuka is currently the Judge of the Bombay High Court. He started the practice of law at the Bombay High Court in 1985 and was elevated as Judge of the Bombay High Court on 23rd January 2012. Prior to his elevation, he practiced on the appellate and original side of the High Court of Bombay in constitutional law and particularly arbitration and companies law. He was on the Senior Counsel panel of Municipal Corporation of Greater Mumbai for several years and appeared in large number of matters representing the Municipal Corporation. Recently, in 2021, a division bench of the Bombay High Court comprising of Justice Dhanuka and Justice Modak in the case of supply chain consulting held that the extension of limitation period by the Honorable Supreme Court in view of COVID-19 should also apply to the refund applications filed under the CGST Act, which was a landmark decision of the time. He is joined by Mr. Kelvin Pool, SC, the Deputy Manager Partner, Rajah and Tann. Kelvin Pool is the Deputy Managing Partner and Head of Rajah and Tann Singapore's international arbitration practice. He has represented clients in a broad range of construction, commercial, and investment treaty disputes in numerous arbitration across the Asia-Pacific region. Kelvin also regularly appears before all Singapore courts and has been described by the Legal 500 Asia-Pacific as a standout arbitration practitioner. He has been recently appointed as a Senior Counsel of the Supreme Court of Singapore and also frequently sits as an arbitrator. Kelvin was recognized as the Dispute Resolution Star in Benchmark Litigation Asia-Pacific 2018 and 19 for construction and international arbitration. He has also been named as a future leader on Who's Who Legal 2019. Kelvin is a fellow of the Chartered Institute of Arbitrators and is also a member of the Core Committee and Selection Committee of the ICC's Singapore Arbitration Group. Kelvin was also a member of the International Bar Association's Working Group on Harmonizing Arbitration Laws in the Asia-Pacific region. Last, but by no means the last, we have Ms. Meenakshi Arora, Senior Advocate. Ms. Arora got enrolled in bar in 1984 and since 1986 has been practicing law at the Supreme Court of India. In 1989, she qualified and became an advocate on record at the Supreme Court. She also had for a brief period worked with Goodwin and Sobel, an international law firm based in Washington, D.C. She was the standing counsel for the state of Himachal Pradesh in the Supreme Court from August 1998 to November 2002 for criminal cases. In September 2013, a full bench of the Supreme Court designated her as a senior advocate, being only the 5th woman to be designated so. Amongst her pro bono cases, she represented a women's organization in Visakhapatnam versus State of Rajasthan, a landmark case which we're all well aware of that banned sexual harassment in the workplace and reinforced the status of international law in Indian courts. Recently, the Supreme Court had taken suo motu cognizance of the Yamuna River pollution and has appointed Ms. Arora as amicus. We welcome the chair and all the panelists. Thank you for gracing the dais, sir. With that, I hand it over to the chair to take it forward, sir. Thank you.
Good evening. I am chairing this session, which has very distinguished speakers on the subject. I am not going to address you on the subject, but I just want to introduce the subject and flag few concerns in the Indian context. All of us know that under 1996 Arbitration Act, parties can by agreement decide the procedure to be followed in the arbitral proceedings. In the alternative, it is left to the arbitrator to decide what procedure should be followed. Ultimately, object seems to be to give lot of freedom to the arbitral tribunal. The idea is to avoid all technicalities which are there in our traditional civil courts. The object was to curtail these technicalities, give lot of freedom to the arbitral tribunals so that the time span of the proceedings is reduced. We always say that we have to consider Section 19 in the context of the procedure followed by the traditional courts. The courts are bound by the Code of Civil Procedure, then strict rules under the Indian Evidence Act, with the object of ensuring that there is expeditious disposal of arbitration proceedings, that we have the special rules under the Arbitration Act, where lot of freedom is given to the arbitral tribunal. In the Indian context, someday we'll have to apply our mind and we'll have to see whether we have really succeeded in the object for which these provisions were enacted. From my own experience as a judge, I found that, I'm saying this in Indian context, I'm not talking about international arbitration, that the evidence recorded in arbitral proceedings is very bulky, is very lengthy, and sometimes when I used to sit over 34 jurisdictions, I used to get an impression that the same evidence could have been recorded by our traditional civil courts in much more concise form. Maybe our mindset is different because in India, as you know, the arbitrators are mostly retired judges. They work for 18 years or 19 years in judiciary, and therefore perhaps their mindset, they are not able to change their mindset. Maybe sometimes I feel after looking at the proceedings that absence of procedure laid down in the statute or in the rules really create a difficulty. I have seen all sorts of documents being placed on record in arbitral proceedings, which normally no civil court will permit it. Now we come to the oral testimony. There will be different kinds of evidence when we talk about arbitration. There will be, of course, testimony of the parties, testimony of third-party witnesses, there will be experts. Then the other form of evidence will be production of documents, both in physical form and in electronic form. Now look at the Indian scenario. We have those very, very lengthy and bulky affidavits filed by the parties to the arbitral proceedings. When it comes to procuring presence of somebody who is not a party to the proceedings for either oral evidence or for production of documents, we have a scenario where we have to go under Section 27 to regular court. Notwithstanding Section 5, today we see a scenario where even applications under Section 27 are contested. Brother Justice Dhanuka has written a detailed judgment, Montana developers, laying down very limited scope of dealing with application under Section 27. But practically what we see today is a picture where even those applications, firstly, they are not heard for quite some time. That delays the arbitral proceedings. In fact, I have come across cases where such applications remain pending for 6 months, 7 months and more. And then there is a contest in those applications. There are other methods of recording evidence. For example, if you have look at subsection 6 of Section 27, maybe there can be an order made by a regular court for taking evidence on commission, because there are, in many cases I have seen there are formal witnesses. I mean, why should the arbitral tribunal waste long time over recording their evidence? So that avenue is also open of getting the evidence recorded to the court commissioners. I believe that someday we'll have to consider whether Section 27 needs amendment. Look at the rules of the arbitrations abroad. For example, this United States Court, there is a provision that the arbitral tribunal can pass an order requiring presence of a witness or directing somebody to produce the document. And then only if that request of the arbitral tribunal is not abided by, then the question of going to the court arises, where court will issue directions. So therefore, what I feel is it's a 1996 Act. In Indian context, we can still say it's a new legislation. So someday we'll have to take a call, we'll have to do audit of how the Act has really worked and whether we have really achieved the object which was sought to be achieved by the legislature. Brother Justice Dhanuka is going to address you on this topic in Indian context. But when we hear Justice Dhanuka in Indian context, Mr. Poon is here, who is such a distinguished person working in the field of arbitration. We want to hear from him what are the practices at international level, what are the practices followed at Singapore. Meenakshi is also going to be a very important speaker. I believe she is going to talk both on domestic as well as international arbitration. Broadly, the scheme of the session will be each speaker will take about 15 to 20 minutes. Thereafter, I'll make brief summary of what they have said, if time permits, of course, and then we'll have a brief interactive session. So I request Brother Justice Dhanuka to address this gathering. Interestingly, I must tell you that Justice Dhanuka has argued Section 34 petitions before me in Bombay High Court, and now he's sitting today with me on this panel. So, Brother Justice Dhanuka.
Thank you, Brother Justice Oak. I will be basically dealing with the evidence in domestic arbitration. What are the provisions, what are the drawbacks, my suggestions. So the source of leading evidence is Section 19, which says that subject to this part, parties are agree on the procedure to be followed by arbitral tribunal in conducting its proceedings. Failing any agreement referred to in subsection 2, tribunal may subject to this part conduct the proceedings in the manner it may consider appropriate. First, Section 19(1) of course says that the tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Now, under the old Act, arbitrator had power to give summary award and to proceed with the proceeding summarily unless otherwise agreed. So let us see how this party autonomy given under 19(2) has helped to proceed with the arbitration economically and expeditiously, or it is causing more confusion. I will deal with few arbitration rules forming part of the prescribed for procedure forming part of the agreement, whether they are consistent with each other, whether they are consistent with part 1 or not. On that I will make my summary. Mumbai Center for International Arbitration provides that tribunal shall not be bound to apply any rules of evidence. At the same time, it also provides that tribunal may require any party to give notice of the identity of witnesses, including expert witnesses, whom it intends to produce, the subject matter of their testimony, and its relevance to the issue. The tribunal has been vested with discretion to allow, refuse, or limit the appearance of witnesses to give oral evidence at any hearing, and is empowered to determine the manner in which witnesses are to be examined. Any witness who gives evidence may be questioned by each of the parties, their representatives, and the tribunal. I have very bad experience I want to share with you about the last part, that witness can be questioned also by the tribunal. So my experience was that when I was appearing in arbitration, it was ONGC arbitration. One of the arbitrator was obviously nominated by claimant, one was by ONGC, and third was presiding arbitrator nominated by both of them. So one of the arbitrator, when the claimant's witness was being examined, his evidence was being recorded, the arbitrator got very tempted to cross-examine him, as if he is not arbitrator nominated by the respondent, but he was acting as an advocate for the respondent. So when I raised objection that, sir, you can't cross-examine the witness, party has already appointed a senior lawyer, let him do his duty, you can't. After evidence is over, if you have any clarification, please ask the witness any question, what you want. Otherwise, in the midst of cross-examination by the senior advocate of my client, if you start cross-examining, it will derail the entire arbitration proceedings. Because questions, cross-examination questions by counsel and cross-examining by the arbitrator makes a lot of difference. The witness may also behave differently. He may lose his confidence, and he may reply something which may not be true. And Delhi International Arbitration Center rules again provides that arbitral tribunal shall not be bound by the Indian Evidence Act or the CPC or any strict rule of evidence. The tribunal may require the parties to produce documents, exhibits, or other documents within such a period of time as the tribunal may determine. The tribunal may require the parties to give notice of the identity of witnesses, including expert witnesses, and has discretion to allow, refuse, or limit the number of witnesses intended to be produced by party. Indian Council of Arbitration Rules of Domestic Commercial Arbitration also grants discretion to the tribunal to consider as far as possible to receive the evidence of witnesses by affidavit and to ask to furnish a list of their witness. It further provides cross-examination of witnesses should be completed at a hearing to be fixed within 15 days. This is, sometimes it may not be practicable. If evidence is filed and within 15 days, suppose hearing is not concluded, then one may say that there is breach of the procedure agreed upon by the parties, which procedure is part of the arbitration agreement. Then what to do, whether that evidence should be discarded, because cross-examination is not commenced within 15 days. So this requires little relook by the Indian Council of Arbitration Rules, according to me. UNCITRAL arbitration rules also provides that each party shall have the burden of proving the facts relied on to support its claim or defense. Unless otherwise directed by the arbitral tribunal, the tribunal may require the parties to produce documents. Then Singapore International Arbitration Center arbitration rules provides that the tribunal is not required to apply the rules of evidence of any applicable law in making such determination. The tribunal, however, is required to discuss the procedure that will most appropriate and efficient for the case. Tribunal is empowered to allow, refuse, or limit the appearance of witnesses to give oral evidence at any hearing. This rule also provides that arbitral tribunal is empowered to ask questions. Now, on one hand, you say that arbitral tribunal is not bound by the provisions of Evidence Act or CPC. At the same time, you also provide that tribunal is empowered to allow, refuse, or limit the appearance of witnesses to give oral evidence. If a party wants to examine, say, 4 witnesses, all 4 may be necessary according to the party to prove his case. In that situation, whether arbitrator can say that, no, I will allow only 2. If he can say, then on what basis? Will it amount to violation of principles of natural justice by the arbitrator by not allowing a party to prove his case? As you all know, disputed questions of fact and disputed documents are required to be proved. I'll take you to the relevant judgments of Supreme Court and Bombay High Court, Delhi High Court, how such awards are dealt with by court if case is not proved, evidence is laid, but disputed facts are not proved, disputed documents are not proved. Now, as against that, suppose there is no procedure agreed upon by the parties how to lead evidence, then the power exclusively goes to the arbitral tribunal. He will decide how to lead evidence, what should be agreed, what should not be agreed. He has a totally unguided power. I'll give you one classic example. I had appeared in one matter, I'm talking about 2000, after 1996 Act came into force. Claimant made some claims for damages under section 73 of the Contract Act. Respondent also made a counterclaim again for damages under section 73 of the Contract Act. Learned arbitrator says that claimant has not laid any evidence to prove his claim for damages. Therefore, I am rejecting his claim for damages. When it comes to counterclaim, arbitrator says that I agree that he has not laid any oral evidence, but according to me, 5 lakhs should be awarded to him. That would be in the interest of justice. Matter went to court under section 34, and the learned single judge looked at the award that the arbitrator has applied different yardstick. In case of claim of the claimant, he says he has not laid evidence under section 73, claim for damages cannot be awarded, it is uncrystallized, unproved claim. But respondents, he exercises discretionary power. Now this discretionary power, according to me, is very dangerous. Though sometimes we find that arbitration proceedings may be very lengthy, we should not give discretionary powers as far as proof of evidence is concerned. Otherwise, every arbitrator will start exercising powers under Article 142 of the Constitution of India. That should be avoided. Now, few judgments on this aspect. The leading judgment was in case of Bareilly Electricity Supply Company Limited versus the Workmen, 1971, 2 Supreme Court cases, 617. There, the Supreme Court was dealing with the provisions of Industrial Dispute Act. The claim was made by the workman, he did not lead any evidence. The employer wanted to lead evidence that we are running in loss, we are not bound to pay any extra compensation to the workmen. They relied upon the balance sheet to prove their financial affairs. Matter went to the Supreme Court arising out of the tribunal, and the issue arose there was that whether any unproved document can be taken into consideration as piece of evidence. Supreme Court held that if suppose a chartered accountant who has submitted this audit report and the client seeks to produce that report to prove his case that this is my audited statement of account and this is my balance sheet, I am running in losses, I am not bound to pay anything. Supreme Court said that no, client has not prepared this, your auditor has prepared this, he is the person who has first-hand information, he is the author of the document, therefore unless author is examined, that document cannot be considered as piece of evidence. Now, our section 19 of the 1996 Act is almost in parametria with the provisions of Industrial Dispute Act which were considered by the Supreme Court in that judgment. That judgment, at least in Mumbai, I must say, we have started following in number of matters, and where there was no evidence at all, documents are still considered, taken in evidence. Because the procedure which we normally follow in arbitration, that both parties, they file their compilation of documents. Then there is statement of admission and denial, which documents are admitted, not admitted. There are 3 categories of statements: existence and contents of the documents admitted, existence admitted, contents disputed. Third is both are disputed. Now, in so far as both are admitted, there is no difficulty. They can be marked as evidence directly by the arbitrator. Existence admitted, contents disputed, where the author of the document may be called upon to lead evidence. And third is where both are disputed, then who is the author of the document and who has personal knowledge about the document, he may be required to lead evidence to prove that. To what extent it should be permitted or followed strictly in arbitration, that is another question. But before I draw that conclusion, I want to bring you to your notice few judgments of Bombay High Court, how this issue is dealt with on unproved documents having been considered, and the awards are set aside on the ground that though arbitral tribunal is not bound by the provisions of CPC or Evidence Act, but arbitral tribunal is bound to follow the principles of natural justice. Now, what is principle of natural justice? Directly, indirectly, we are applying the provisions of Evidence Act, which is unfortunate. But my suggestion as a student of law at some stage would be that because there is inconsistency in the rules providing for procedure for recording evidence, there has to be an uniformity. Instead of giving that party or autonomy to frame rules whatever they want, what is happening is they have just cut and paste some part of section 19 of Arbitration Act, some part they have copied from some other rules. Some powers are given to arbitrator drastically, some are not given, and this is creating a lot of confusion with great respect to the institutions having formulated some rules. Perhaps some part of it may be contrary to part 1 of the Arbitration Act. And Bareilly Electricity was subsequently followed in another judgment of Supreme Court in case of Sanjong Engineering and Construction Company Limited versus National Highway Authority of India, 2019-15 Supreme Court cases 131. Supreme Court has held that a finding based on no evidence at all or an award which ignores vital evidence in arriving at its decision would be perverse and liable to be set aside on the ground of patent illegality. Now, some views are that liberal approach should be taken when you deal with an award under section 34 of the Arbitration Act. This is another approach of the Supreme Court that no, if award is based on no evidence or it ignores vital evidence, then that award has to be set aside on the ground of patent illegality. So unfortunately, judgments are there on both sides, and it becomes difficulty for the judge who is hearing section 34, because in the same judgment, one advocate will rely upon one paragraph, and in the same judgment, another advocate will rely upon another paragraph. And judge has to pick up one of the paragraph which would be suitable in the facts of that case. Then after Sanjong, I'll just give you citation because time is short. Bombay High Court in case of ONGC versus Inter-Ocean Shipping India Private Limited 2017, 5 Bombay cases, reporter 8, has held that arbitral tribunal is not bound by the provisions of the Evidence Act. The tribunal is bound to follow the principles of Evidence Act and natural justice in the arbitral proceedings. The arbitral tribunal cannot dispense with the proof of such documents by overlooking the agreed procedure between the parties. Similar views also taken in case of Pradyuman Kumar Sharma and others versus Jaisagar Sancheti 2013 5 MLJ 86. Then in case of Bywater Penstock Limited versus Municipal Corporation of Greater Bombay 2010 SSC Online Bombay 1784. Then in case of Nazim Kazi versus Konkan Railway Cooperative Bank 2013 SSC Online Bombay 209. Now, about my Lord Justice Oak referred to section 27. If that requires amendment, I fully agree with his lordship. What is section 27? Because what powers are vested with the court under Civil Procedure Code for issuance of witness summons to produce a witness or documents. Unfortunately, those powers are not given to the arbitral tribunal. Now, as a result of that, what is happening is that a party who wants to issue witness summons, that witness is not cooperating, or documents are in custody of some third party, he is not producing, then what happens? Then you have to make an application before the arbitral tribunal. He should be satisfied that yes, production of this witness or production of this document would be relevant. He will pass an order, but he can't issue witness summons. On the basis of that order of the tribunal, then an application is made before the civil court, as may be having jurisdiction. Then on that application under section 27, which is for taking court's assistance for recording, for issuance of witness summons, application would take some time. Some advocates will oppose that application, that the arbitrator could not have passed this order, it is wrong. That I had occasion to decide. My Lord Justice Oak has already referred to that judgment in case of Montana Developers Private Limited versus Aditya Developers 2016, 6 Maharashtra General 660, where court held that whether arbitral tribunal has passed a wrong order that presence of a particular witness would be required, whether court can go into that aspect while considering an application under section 27, because on the basis of the arbitrator's order, party applies for issuance of witness summons. So I had occasion to decide that in view of section 5 of the Arbitration Act, which provides for very limited remedies available under the Arbitration Act, court cannot go into whether arbitrator is wrong or not. Of course, if your remedy is there in law, it may be at the stage of section 34, when you challenge the final award. Along with that, if that order can be challenged, you can take your chance, not at this stage. Another matter where very interesting issue arose, where fortunately I had occasion to decide that issue, that venue of the arbitration agreed upon by the parties was Mumbai. Arbitrator was from Mumbai. Respondent wanted to examine a witness. That witness was unable to come to India. He was a resident of Singapore. But his evidence was necessary. Arbitral tribunal gave a finding that yes, I agree with you, his presence would be necessary. Now, how to call that witness here? He is not willing to go because he was under apprehension that if he comes to India, he may be arrested because some investigation was going on against him. So he doesn't want to come to India, his evidence can't be closed. What to do in this type of situation? So learned arbitrator made an award that you seek court's assistance under section 27. So arbitrator cannot issue witness summons. Our High Court or Civil Court cannot issue any witness summons to a party staying abroad. So what to do in this type of situation? So somebody pointed out that letter of request can be issued. You will issue a letter of request upon the Singapore court. Singapore court will issue witness summons upon that party staying abroad, and these parties who want to examine him and who want to cross-examine, they can go there and record his evidence. But very interesting question arose that if parties have agreed that venue is Mumbai, then if this commission is recorded at Singapore, whether there will be change of venue. So one of the party who wanted to scuttle this proceedings or benefits of the order passed by the High Court, by the arbitrator, he said that no, sir, I am not agreeable because venue, Mumbai means Mumbai, whether it is for recording evidence. If this witness would not have been at Singapore, he would have been at Mumbai, then evidence ought to have been recorded only at Mumbai. So Bombay High Court took a view that there is no question of any change of venue because this is only for the purpose of facilitating the recording of evidence by commission. We will issue a letter of request to the Singapore court. Singapore court will call that witness one order, what was passed, direction passed by Bombay High Court was that let arbitrator himself act as a court commissioner, because parties may not agree to appoint anybody from Singapore. So that part was modified by the Supreme Court. Supreme Court said that no, let arbitrator should not act as a court commissioner in the same matter, but let arbitrator nominate his nominee who will act as a court commissioner. Both parties can go there, there will be no change of venue. And as and when that evidence would be produced in India before the arbitrator, that will be at Mumbai. Therefore, there is no question of change of venue. Now, one more topic I will try to cover within 2-3 minutes about evidence whether can be laid in section 34 petition. There were two important judgments delivered by Supreme Court in case of FIJA developers and Intertrade Private Limited versus AMCI Private Limited and another 2009, 17 Supreme Court cases 796, where Supreme Court held that the applicant is permitted to file affidavits of his witness in proof. A corresponding opportunity is given to the respondent to place his evidence by affidavit. Court may permit cross-examination also of persons swearing to the affidavit. Similar view was taken by the Supreme Court in the judgment authored by Justice Nariman in case of MK Global Financial Services Limited versus Girdhar Sondi, 2018-9 SSC 49, and also in case of Canara Nidhi Limited versus Shashikala, 2019-9 Supreme Court cases 462. Now, as a result of this judgment, whether 34 proceedings, how do you lead evidence? Because it is not original proceedings, it is arising out of the award rendered by the tribunal after recording evidence, whether it is oral evidence or documentary evidence. Thereafter, the high-level committee was appointed to review the institutionalization of arbitration mechanism in India, headed by my Lord Justice B.N. Sri Krishna, former judge of Supreme Court, who recommended amendment to section 34(2)(a) of the Arbitration and Conciliation Act by substituting the words furnishes proof that with the words establishes on the basis of the arbitral tribunal's record. Now, as a result of that, the problem created because of the two earlier judgments of Supreme Court permitting evidence at the stage of section 34, the party understood that judgment by saying that I have to prove whether award is in accordance with the grounds set out under section 34 or not. So prove means I can lead oral evidence also. But because of that amendment, now words established on the basis of arbitral tribunal's record means whatever evidence was laid before the arbitral tribunal, on that basis you have to prove whether award can be set aside within the grounds permissible under section 34(2) or not. But in a later judgment, post-amendment, in case of Alpine Housing Development Corporation Private Limited versus Ashok Dhariwal, 2023, SSC Online SC 55, there, considering the amendment, Supreme Court took a view that in exceptional circumstances, court can still exercise powers to permit party to lead oral evidence with power to cross-examination. Now, this judgment as a student of law, I can't say more than this, but this requires some debate, and at some stage, court may have a relook, because permitting evidence at section 34 stage may create lots of complication. This is not a situation where Order 41 Rule 27 of CPC can be extended to section 34 petition. Of course, Supreme Court guarded there by saying that a strong exceptional case was made out by the respondents to permit them to file affidavits or adduce additional evidence, and also permitted to the appellant to cross-examine or to produce contrary evidence. One last suggestion I want to give, that Schedule 8, as all of you know, originally provided for qualification and experience of arbitrator required for his appointment as an arbitrator. So person having legal background should have knowledge of law, only could be appointed as an arbitrator. Unfortunately, that Schedule 8 is deleted by Arbitration and Conciliation Amendment Act 2021 with effect from 9 November 2020. So no qualification is required, anybody can be arbitrator. I'll just share my 1 minute experience on that, very pathetic experience. Before an engineering arbitrator, did not know ABC of law, how to lead evidence, and witness was examined, contractor's witness was examined. I was cross-examining him. So he was looking blank completely. So I said, sir, objection is raised by me. You have to give ruling. What ruling? What order can I pass? So my opponent very cleverly informed him that you have two options, objection sustained or objection overruled. He said, okay. Next objection. Now he could not grasp that objection sustained and objection overruled. So sometimes by slip of tongue, question remains, sometimes answer remains. And end of the day, after recording evidence of 10 witnesses, but still, in spite of this, that award was not set aside by High Court, because court's powers are limited. Now only one small suggestion about, which I have already given, about the uniformity in procedure. It shall be prescribed in the act itself, instead of giving this party autonomy to have different rules. That is creating complication. One set of rules may give wide powers, one may give no powers, or third may be without rules, full powers to the arbitrator, and all sorts of problems may be created. Only 1 minute only I'll take, with your permission. My Lord Justice Oak referred to bulky evidence in arbitration. Bulky evidence, my personal experience is that it becomes very bulky when there is ad valorem fees paid to the arbitrator. And when there is schedule for fees, he is in hurry to finish it fast. So per day or part thereof, arbitrator behaves like a court commissioner with no power of giving any ruling whether questions can be permitted or not. So this is another factor. Arbitrator should behave himself whether he gets less fee or more fees. He is occupying the chair of a judge. So thank you very much for giving this opportunity once again.
Mr. Poon, yes.
Thank you, Justice Oak. Actually, in many ways, the law in Singapore and the law in India is quite similar when it's written. It is true that in our act in Singapore, the tribunal is the master of the whole procedure, and he decides or she decides what evidence goes in, what evidence goes out. And in a way, when I heard Justice Dhanuka describe Section 19 of the Arbitration Conciliation Act, that seems to capture that same spirit. But what's quite clear is that when we move the legislation from just mere words to practice, a transformation has taken place. And as I hear him describe the various scenarios that we face here in India, there is some divergence in the sense that the courts do not necessarily here give full effect to that freedom for the tribunal to decide what should go in or what should go out to the record. So maybe just a few points of what was shared earlier. In Singapore, generally, the courts do not intervene. And the only time I think the court will intervene is when there is really some damage to due process. There's some breach of natural justice. And very recently, there was a case that highlights the position. There was an arbitration under the maritime rules which states that unless parties agree, you needed to have an oral hearing with witnesses. One of the parties said, no, I think this case is simple enough. I'd like it to be a documents-only arbitration. And the other party said, no. In fact, one of the critical parts of my case requires that I get my witnesses in to explain what the documents mean. The arbitrator, for reasons best known to him or herself, decided to exclude the witness evidence completely and entered an award in favor of the party seeking a documents-only arbitration. That award was challenged and set aside by the court. And the reason for that is not because of any procedural defect per se. I think the critical point that the Court of Appeal emphasized is that the award had to be set aside because there was a breach of natural justice. One party has already said that there was a critical evidence that had to be given by oral testimony, and in fact the rules provide that oral hearing was needed. So it's the combination of both factors that meant that the award should be challenged and disturbed. If there's any other situation which does not rise to that degree of severity, it is unlikely that the award would have been set aside. And that really is the principle that the Singapore courts and I think other model law jurisdictions hold quite close and dear to. But what this shows is, it highlights, I think, the point that this panel is entitled. It asks the question, are there any rules of the game in arbitration? Actually, the answer is there are rules. The problem is that there are too many. And so the challenge is not whether there ought to be rules, but the challenge really is about ordering the rules and getting parties to appreciate what rules should be applied in the arbitration at the outset, or to craft a series of rules or guidelines that can best assimilate and form what's probably can be described as the best practices for international arbitration. And we do have that, actually, in the international arbitration context. We have the IBA rules on the taking of evidence. The IBA rules began as a rules for arbitrators starting in 1983. Since then, there have been various formulations in 1999, 2010, and more recently, 2020. And the rules do set out what we can describe to be a fairly balanced approach. Balanced in what sense? The uses of arbitration, we can describe them broadly to fall into two buckets, right? The civil law tradition and the common law tradition. So the IBA rules set out with the objective of trying to reach a balanced position that can be applied uniformly to all manner of arbitrations. And it's meant to be a set of rules. So what sort of rules have come about? So in the civil law jurisdiction, there doesn't tend to be any document disclosure. In contrast, in the English system, there is, of course, discovery. In the American system, an even more aggressive form of discovery. So they struck a balance and said, look, it's not as if in all arbitrations there should be no documentary production, but neither can be such a wide-ranging disclosure process like what you're used to in America. You have a process by which you can make requests for production. At the very start of the life of the IBA rules, they said you must describe the document that you want. It's almost like a subpoena for documents. You identify the documents and you produce them. But again, with discussion among the IBA committee, that was slowly expanded to deal with specific and narrow categories of documents. But what this shows is that the rules that we are talking about cannot be too rigid. I think in an earlier session, Mr. V.K. Rajah posited that ADR should not mean alternative dispute resolution, but it should instead be called appropriate dispute resolution. And if you're talking about an appropriate dispute resolution that works for the parties, then there needs to be sufficient flexibility to ensure that what's being used can serve the purposes of the parties to address the specific complexity or simplicity of the dispute before the arbitrator. So we are talking just now about disclosure. There's also a very tricky question about witness preparation. To what extent can you speak to your witness before he gives his evidence? Again, there's a sharp tension, right? In the civil law jurisdictions, in some of these countries, they'll say, no, you just can't do that. In America, it is perfectly acceptable. In fact, it is a dereliction of duty of the lawyer's part not to familiarize the witnesses on what the process is about. So in IBA rules, it says you can meet the witnesses to prepare their statements. And really that is an important point. And that came up in one of the Singapore decisions recently about the extent to which you can prepare your witnesses. I think generally there's only one touchstone, right? All of us here are lawyers. There's only one touchstone. The touchstone is the witness must tell the truth. And he must tell the truth from his perception of the facts. So witness preparation itself is useful, is helpful, because in some ways it can help streamline the arguments and the facts for the tribunal before the hearing. So Justice Oak earlier asked the question, what do I do with reams and reams of bundles of witness statements? How of them are not relevant? I suppose it's very difficult in practice for a tribunal to say, I want a witness statement with only 10 pages or 15 pages. But I think with time, experienced counsel learned that it's not in their interest to write long witness statements. In fact, earlier on, just before this session, I was having a chat with Mr. David Brimmer-Thomas outside, and we're describing a situation that's occurred for both of us, where our opposing witness was being cross-examined, and when pointed to a paragraph, the witness looked up and said, oh, did I write that? I mean, if that was a very nice way for me questioning the witness, I'll be mortified if I was on the other side. And perhaps with time and practice, you'll soon realize that it's more important for a witness to say what he wants to say in as brief a way as possible, because there's a limit to what the witness can actually remember after all. And that may be a better way in practice to eventually manage this issue of long witness statements. And when it comes to one last issue is, of course, the issue of privilege. Again, there are various different standards across different jurisdictions, and the IBA rules have now set out a list where the tribunal should consider whether to exclude evidence. But in the end, in practice, the IBA rules do not really operate as rules, in a strict sense that every tribunal is bound to apply it. In fact, in practice, most tribunals will ask counsel, are you agreeable to having the IBA rules as guidelines? And that's really to ensure that we still have the procedural flexibility to shape the rules to meet what the tribunal and the parties require. And that maybe takes me to a point that Justice Dhanuka made right at the end of his very illuminating presentation. And that's whether there should be actually greater clarity in the rules, such that we can say, this is the rule, follow it. There is a certain attractiveness to certainty, because it makes it clear for users to know what to expect, what they should do to advise their clients. But if we come back to what makes arbitration so attractive, one of the points is that arbitration is inherently flexible. And again, the words of Mr. Rajah, the appropriate formula can be fashioned. So maybe, if I may respectfully say so, you enrich the arbitration community to have rules drawn up, and in the process, active discussions made between arbitration users, so that there's a greater education as to what solutions can work in what situations. And conferences like this do a big part in raising the awareness and helping parties reach some consensus as to what should be done at any hearing. So then the question is, if rules are not rules and only guidelines, what do we do? So in my humble suggestion is that tribunals need to take a more active role in discussing these issues with parties at the outset of the hearings, so that whether it be in the procedural orders or in the terms of reference for the ICC arbitrations, there's scope for parties to have a good sense of what rules will come to play, so that there be a level playing field. And more importantly, when their clients are advised by the lawyers, they know what to expect and are not left feeling that they are now in some twilight zone where what is proceeded does not quite match what they expected in the arbitration. And that only will serve to undermine the legitimacy of arbitration, which we know we can't afford to have, given its important place in commerce. So to round up, maybe I'll just leave with 2 examples of where cultures have been problematic in my experience. The first was a case where I was co-counseling with lawyers from a different European jurisdiction, not common law, and we were in a cross-examination. So our witness was being cross-examined, and leading question after leading question was put to our witness. And when my co-counsel stood up and said, "It is my turn now to re-examine," and he similarly asked leading question after leading question in re-examination. And the tribunal says, no, you can't do that. This is re-examination. You must ask only open questions, not leading questions. And of course, my co-counsel with some justification said, but my learned friend kept asking leading questions, so why can't I? And of course, from his perspective, you could feel the indignation because of the culture that he came from. And of course, that was clarified at the start of the cross-examination by the tribunal. That could have addressed some of the misgivings. So mindful of time, and of course, eager to hear the views of everyone here and my other panelists, I will stop here for now. Thank you.
Meenakshi. Yes.
I'd rather take the podium. My chair is a bit too low.
Okay. Okay.
Thank you. Yeah. So thank you, Justice So. After hearing Justice Dhanuka and Mr. Poon, I really don't know. I have really much to say out there. But then I picked a topic for myself which is slightly different and yet is an aspect that covers with the arbitrator's jurisdiction to decide the freedom that the arbitrators have to decide on the aspects of admissibility, probative value of the evidence placed before them. Now, what I'm going to take up here, and very, very quickly, because I know we've overstepped our time, is admissibility of unlawfully obtained evidence. This is a very vexed area in international arbitration. It also has a room in the domestic arbitration. And therefore, there seems to be a huge divergence between the arbitral tribunals across different jurisdictions on how to treat the unlawfully obtained evidence which is presented in course of arbitration. Now, keep this in mind that we are talking in the realm of WikiLeaks and the documents from WikiLeaks being introduced in arbitration, international treaty, arbitrations, etc. So let's go back a little bit into the history here. About 70-odd years ago, for the first time, International Court of Justice first triggered this debate involving the unlawfully obtained evidence. So about 7 decades later, we are still in a very vexed state of this particular aspect. With CyberLeaks and WikiLeaks, as we know them now, which are a more recent phenomena, but about 70 years back, the dilemma whether to admit documents that had been obtained in violation of a law arose for consideration in 1949. This was the Corfu Channel case versus Albania before the ICJ. What UK had done here was that its vessels that had been passing through the Albanian waters had faced mines, and they had the 2 vessels which had been attacked. So while the matter was before the ICJ, UK took this process to carry out mine sweeping within the territorial waters of Albania. And after carrying out this mine sweeping, the evidence that it had gathered, it placed it before the ICJ for consideration for the purpose to decide its case. The ICJ refused to take this particular evidence on record. It refused this evidence in support of UK's case against Albania, but it did not go in at that stage 70 years ago to decide why we would not take it on a legal principle. But what the ICJ said at that time was something like this. Intervention is perhaps still less admissible in the particular form it would take here, because this was an evidence collected through intervention. For, from nature of things, it would be reserved for the most powerful states, and that might easily lead to perverting the administration of international justice itself. So the only principle that it culled itself out was administration of justice. But more than that, ICJ did not decide at that time, about 70 years ago. Now, several decades later, the probative value of an unlawfully sourced evidence not only remains unresolved, but it has become even more challenging in view of the WikiLeaks documents which are now sought to be introduced. So let's not forget that in recent years, the volume of electronic communication and electronically stored information has increased. Because of this ever-increasing pervasive nature of ESI in all jurisdictions, it also increases the risk of hackers accessing this information. However, the dissemination of such classified information, although may violate the national laws and other criminal laws in a given country, but illegality under a national law does not necessarily translate automatically into an international wrong. So that's one very important principle we have to keep in mind when we take this evidence that has been sourced illegally in international commercial arbitrations. In the recent trends in international arbitrations, and also perhaps in the domestic, it has shown that there is increasing tendency to rely upon material and evidence which may be available in public domain. Now, the word that I'm using here is public domain, and very consciously at that, and such as on WikiLeaks websites or like the ESI. However, there's also an increasing question, including the conflicting and diverse views as to the probative value of admissibility of such documents introduced into the evidence. But before I go further, I want to clarify one aspect, that the principle of application of unlawfully sourced evidence is entirely different in the criminal law, human right jurisdiction, as compared to the civil law or in a proceedings like this. So I am not discussing at all anything which relates to the human rights or the criminal law aspect, where this may be clearly no in many jurisdictions. But on the civil side and in the arbitration, there are divergent and vexed views that have been coming up, and there is no one single resolution to this particular issue on this. Now, the Corfu Channel judgment that had come from the ICJ, which it only went on the principle of proper administration of justice. That was the test that the ICJ applied at that case. But ICJ also went on to say that such evidentiary practice of producing unlawfully sourced evidence could run afoul of principle of proper or sound administration of justice. ICJ therefore strongly rejected the violation of law for purpose of obtaining the evidence, although the legal standards applied for such rejections were not really very clear at that particular stage. Subsequently, in Timor-Leste versus Australia, now this is the standards that ICJ has fixed, and we'll just move into what is happening in the arbitration circuits. Here, the Australian government used illegal means such as hearing devices, which were planted in the cabinet offices of Timor-Leste to gain upper hand during a treaty negotiation. And separately, they also raided their office to seize some of the privileged documents. The International Court of Justice ordered the Australian government to return all the unlawfully obtained documents to Timor-Leste government during the proceedings initiated before it. So what the ICJ did was, it did not even allow the documents to come in on record, but directed them to be returned to Timor-Leste so that they may not even be taken on record. Now, this is where the ICJ's test, going back 70 years, and more recent in the case of Timor-Leste versus Australia, stands. But what happens then in the arbitration jurisdiction? One of the principles that most arbitral tribunals are applying is the principle of good faith. And there are three examples, and I'll take you through it very, very quickly. The first one that arose in this aspect of good faith application to not take on record an unlawfully obtained evidence was the case of Methanex versus United States. In Methanex, what had happened was that Methanex Corp, a Canadian company, which was a distributor of a particular product, and this was a UNCITRAL arbitration, had claimed a huge amount of damages because there was a ban on a use of one of its product in the US. Now, what Methanex here had contended was that it was being a violation of fair and equitable treatment, and their national treatment had expropriated its assets, etc. US challenged the introduction of evidence of documents which had been copied unlawfully from a private files of a witness of their company. The tribunal excluded the evidence which it confirmed as having been obtained unlawfully, and they said, you have obtained this evidence through trespassing onto private property, rummaging through the dumpsters inside the office buildings of the other person's for the documentation. Now, the tribunal based its decision on a principle of good faith. They said good faith does not allow you to go into other person's place, intrude into their privacy, get your evidence out, and then place it before us. And they relied upon Article 15.1 of the UNCITRAL rules that specifically prohibited, that required exclusion of evidence of documents such which were materially unlawful. But here, I want to pause for a moment. We cannot forget one fact, that UNCITRAL, like also the ITSE, allows the arbitrators a complete freedom to decide on the procedure of taking the evidence, etc. But be that as it may, they said we exclude. The same thing happened in EDF versus Romania. Now, EDF here had a case against the Romanian government. Its contract had been terminated, and it said that there is corruption, etc., that is involved in this case, and that is why my contract has been terminated. I'm entitled to this huge damages. What EDF did, and EDF was a UK company, this was again a treaty arbitration, so there was a UK-Romanian treaty here under which this was being done. EDF's purported evidence of corruption included audio tape recording of a meeting between an agent of EDF and a member of the Prime Minister's staff of Romania. What the tribunal said, he said, first of all, the evidence has been illegally obtained according to Romanian law. Now, the principle is shifting. That is what I'm emphasizing on. The different tribunals take different positions, and I will go on to cite two examples very quickly where the tribunals have allowed WikiLeaks documents in. So that is where I'm saying that there is a little vexed situation out here. So here the tribunal said that in Romanian law, you have illegally obtained it, and they applied the Methanex Corp principle, and they said principle of good faith and procedural fairness has not been respected by EDF. You have not informed the person whose audio recording that you are making. You have intruded into the privacy. It was not allowed to be taken. And the final basis, what the tribunal went on to was that the audio tape meant to prove the allegation of corruption primarily was on the basis of lack of authenticity. Now, this is yet another principle, lack of authenticity, that has been applied by the tribunals not to allow an illegally obtained evidence from being taken on record. But there is yet another example of Clementonia, but I'm not going to cite that because of the time that we have. So the next principle that comes up after this is the probative value. Now, the probative value has arisen in the wake of WikiLeaks documents. In November of 2010, about 25,000 confidential diplomatic cables from 274 embassies, consulates, and missions of the US were leaked. While these leaked documents were illegal to be sourced out in the US, but they were not per se considered as evidence obtained in violation of international law. So in the US, it was illegal, but in the international domain, it was not considered for the reason that whistleblowing is not prohibited under any rule of the international law. So WikiLeaks were meant to be a whistleblower evidence, which were not really illegal in the international domain. Now, these documents, WikiLeaks documents, then found their way in the public domain. Anybody could access them on the WikiLeaks websites. If you found material that met with your requirement in a particular arbitration, you may go ahead and sue. There were two very important cases under this context where, in one case, the WikiLeaks documents were taken in on record, but in the other case, they were not allowed to be taken on record. The first case is Yukos versus Russian Federation. This is a 2014 award, and the tribunal admitted these documents in evidence, which had been obtained through WikiLeaks, by saying, now this is what the tribunal held there. Absent direct testimony from PwC, the tribunal must draw its conclusion from testimony of the claimant witnesses, correspondence amongst Yukos, PwC, external advisors, and Russian authorities, and testimony of the personnel. There are also contemporaneous, so after looking at those testimony, it goes on to record, there are also contemporaneous US State Department cables which emerged via WikiLeaks and reveal the candid and unguarded views of PwC's senior management. So, what was sought to be produced as evidence of PwC counsels was supported by the WikiLeaks contemporaneous documents, and therefore it was taken, and it was taken into record. But in ConocoPhillips versus the Republic of Venezuela, here ConocoPhillips had huge investment in oil and gas in Venezuela. Venezuela wanted to nationalize it. Before the arbitration, the issue that was being raised was that Venezuela hasn't offered them a fair compensation or even called them for some kind of a compensation, etc. So the tribunal then took a view that Venezuela government has not come forward, has not engaged in any negotiations to give them, and awarded a huge compensation to ConocoPhillips. After the arbitration was concluded, the Venezuelan government, through the WikiLeaks, found documents which clearly establish that through the US Embassy, through the US Embassy, I'll just close it. Through the US Embassy, these documents actually had come in, and Venezuela had offered compensation. But one of the arbitrators said, these documents are in public domain, therefore we should take it. The others did not agree because it was reopening the award. And that is how the documents were not taken on record. But the issue that I'm trying to make out is that there is a huge vexed issue here of documents like WikiLeaks, which are in public domain, which in certain arbitrations support the cases, and in others they do not. Now, I will not take you very much further on this. I realize that we have a time issue here. I will just pause it by saying here, the LCIA, UNCITRAL, and ICSID give a huge leeway to the arbitrators to determine as to the admissibility of the evidence, the procedures if the parties don't agree. Whereas, as Mr. Poon said just now, the International Bar Association rules are much more structured, and they actually do not allow specifically and unlawfully obtained evidence to be taken on record. So we have a little bit of guidance, a little procedure, but not if we are doing an arbitration under the UNCITRAL or under the ICSID or under the LCIA. In India, I'm just winding, I just need 2 minutes, that's it. In India, in Meghraj Patodia, we have specifically taken a view that we can take on record unlawfully sourced evidence. So we have a position which is through a judgment by our courts. Lastly, ending here, the research shows that the evidence is either generally admissible. Now, in generally admissible, you have about 9 countries, such as Bulgaria, Canada, Chile, China, Egypt, Japan, Malaysia, United Kingdom, and United States. Generally inadmissible. You have 6 countries: Brazil, Croatia, France, Italy, Russia, and Slovakia. Completely inadmissible, you have Greece, Ireland, Peru, and Spain. And then, inadmissible, if balancing interest favors its exclusion. It's a principle that's applied. Balancing interest favors the exclusion. You have 8 countries: Australia, Bolivia, Germany, Kenya, Nigeria, Slovenia, South Africa, and Switzerland. I rest it here. I would put it, we are in an area which we haven't still finalized, an area that still needs to be tested. if we introduce an evidence that is being unlawfully obtained, we cannot overlook a fact that our award might be executed finally in a country which may fit into an inadmissibility or in balancing of the rights in inadmissible, and you may be fixed with a very vexed issue there while executing an award. Thank you so much for hearing me out this evening and having me.
Thank you, ma'am. With permission of the chair, we can have one question, although we are over time.
It's often said that just to introduce myself, I'm Bhavik Rajani, I come from Goa. It's often said that the arbitrator decides the dispute, but he mediates the procedure. So one of the questions I had to ask Mr. Kelvin Poon is, one of the systems followed in Singapore is to allocate equal time for leading evidence. But if there is an asymmetry on the number of witnesses being produced from both the sides, how does the tribunal deal with it? Should the criteria be the number of issues involved in the dispute, or would natural justice require you to give enough time to both the parties to lead evidence as much as they want?
Thanks for the question. Unfortunately, I'm not sure I can give a bright line answer as to how it is done. I think I'll do the lawyer's thing and say it depends. And it really depends on what explains that the large asymmetry in terms of the witness testimony. Is it really tactical? And this is a point which I didn't really touch on, and it's quite a live problem. That is the ethical dimension on taking evidence. Because the rules are there, but we have lawyers who use the rules in a way that's not quite right. And sometimes we do get this situation where one party floods the tribunal with many witnesses to choke the other side's time for effective cross-examination. And that really calls for a delicate handling by the tribunal, because as I mentioned earlier, the key concern is to make sure that you've not violated due process along the way in structuring the procedure. But if you find that there are many duplicative witnesses, I think the tribunal should just ask the pointed question: do you really need X, Y, Z to say the same thing? And to deal with it in that way. I hope this works.
I have a short question. One of the party came to us for a negotiation. During the negotiation, without telling us, illegally he has recorded my statements. He has given the transcripts to the arbitrator. In fact, I am not a party to the dispute. Government of India is the dispute, and he made me a party, asked me to come as a witness. Is it legal or illegal?
Illegally procured evidence, my sister just told you what is the relevance of that.
Thank you. With that, we'll end this session. I'm so sorry if there are any further questions. And that also draws curtains on the second day. Okay, sorry. Please go ahead. Mike.
Okay, I'll introduce myself. I'm Abhay Malhotra, basically practicing in the High Court. I'm also an arbitrator. My problem is not with being an arbitrator, but really as a counsel when I go for arbitrations, and where the arbitrator appointed is a sole arbitrator who's not a legal practitioner. Taking from what Justice Dhanuka said, he may be an engineer, an armed force, retired personnel, anyone, but he doesn't have the legal expertise to really arrive on a proper conclusion, what is proved, what is relevant, what is needed to be overruled, what is needed to be sustained. All that he doesn't know, and he's not willing to learn either. So with the limits of judicial review, after the award comes, it becomes a very frustrating process from that point of view. And since the topic is what are the rules of the game, so my suggestion really is that a rule be made that the technical experts be used as in the other tribunals. You have a judicial member and a technical member. So in maybe the construction cases, oil and gas cases, you have a technical expert on the tribunal. But in simple cases where you have perhaps a builder-owner dispute and it is going to be resolved by a sole arbitrator, a legal practitioner should be preferred, and that rule should come in black and white. That's my suggestion.
Can I take 2 minutes?
Sir, you have to tell me if you have 2 minutes.
Though I don't allow lawyers to argue, but I'm seeking 2 minutes time from you.
Sir, probably I'll take that liberty later in court.
Right. Only one question to Brother Justice Dhanuka. Based on your experience as arbitration lawyer, are you suggesting that in Indian context, the flexibility given to arbitrator is proving to be counterproductive?
It is. What is happening is that an arbitrator from legal fraternity, he wants to apply the principles of evidence act strictly. And a person not from legal fraternity, he tries to avoid recording evidence because he will not be able to do it. So he will apply summary powers. This is a wide gap. I fully agree with you what problem you are facing. Because in arbitration, I have faced so many problems. I'll just take 1 minute. It is not on evidence. I cited one judgment of Justice Deshmukh there on issue of limitation. Arbitrator was engineer and my opponent was so techno-legal. He was engineer plus LLB. So when I cited judgment on limitation, so quick objection of the opponent was that this judgment can't be relied upon in arbitration. I said, why? The learned judge in his order says, in my opinion, this is the limitation period. So opinion is not a judgment. That was the first objection. And second objection was that this is a judgment of court. At the most you can rely upon award in arbitration as a precedent and not a judgment in arbitration. So all sorts of problems we are facing in arbitration.
2 points well taken, Brother Dhanuka. One is unification of the rules. But I want to add a caveat to that. Unification, yes, I understand. But if you try to codify it, then we may end up in evolving one more civil procedure code for arbitration. That I think we should avoid. And the last suggestion, very bold suggestion, but I appreciate that when we higher courts decide petitions under section 34, our judgment should be very precise so that lawyers don't get too much of leeway. I take that suggestion from you.
Take a clear way, view, clear view.
Agree.
Don't be, it is also possible, that is also possible. So both views are possible, therefore both parties are relying upon the same judgment. That is the only
Therefore, I said it, well taken. And one more question, Mr. Poon, to you. Very interesting point you made about lawyers preparing witnesses. In lighter vein, I want to ask you a question. Are lawyers permitted to charge separately on this count?
Lawyers do charge, but not separately. I think it's part of the work.
Because if we introduce here in India, that will be welcomed by the lawyers. One more head in the bill, preparing witness. And last thing, very interesting presentation by Meenakshi Arora, but this concern is surely there. We need to adjudicate upon this. But the other point of view is that truth must always prevail.
Yes, that's
Let evidence come from anywhere.
that is also
That is a point of view. But of course, this will have to be balanced, I think. Appropriately balanced.
what
Right.
some forums say. In fact, UK in its Court of
Right.
Appeals has accepted WikiLeaks on the same principle of finding the truth, because finally it has to be the truth.
Can close.
Sir. With that, we draw curtains on the second day of the Delhi arbitration weekend with thought-provoking, fantabulous sessions. On behalf of the committee, I, Shashwat Bajpayee, thank all the panelists and all the audience, August gathering, for their support. Thank you.